unmarried heterosexual or queer couples should not adopt that needs to be closely examined. Civil marriage or recognition of any such relationship with such status cannot exist in the absence of a statute, may not really be equitable at times, and can result in women being exposed to unintended vulnerability. On the issue of adoption, we express our disagreement. We have voiced our concerns and laid it out in some detail, which I do not wish to read. This is not to say that unmarried couples, whether queer or heterosexuals, are not capable or suitable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, the likelihood of their joining and cohabiting cannot be ruled out. In such event, de facto family unit can and does come about. The underlying assumption in the law as exists is that such unmarried heterosexual or queer couples should not adopt. That needs to be closely examined. In our considered opinion, this is not, however, one such case where the court can make a departure from such a rule and require the state to create social or legal status. What is being asked for by the petitioners is state intervention in enabling marriage between queer or non-heterosexual couples. Civil marriage or recognition of any such relationship with such status cannot exist in the absence of a statute. The demand hence is that of a right of access to a publicly created and administered institution. Agree with the conclusions of the learned Chief Justice with respect to the inapplicability of the SMA, and we also add certain observations. A gender-neutral interpretation of SMA and its provisions, much like many seemingly progressive aspirations, may not really be equitable at times and can result in women being exposed to unintended vulnerability, especially when genuine attempts are made to achieve a balance in a social order that traditionally was tipped in favor of cis heterosexual men. The purpose of the terms like wife, husband, man, and women in marriage is to protect a socially marginalized demographic of individuals. For instance, women facing violence by their partner have a right to recourse under the Domestic Violence Act, which assures and is meant to assure that the victims are safeguarded and provided relief. In fact, provisions of SMA for alimony maintenance confer rights to women. Likewise, certain grounds of divorce, conviction of husband for bigamy, rape, etc., entitle the wife additional grounds. Other provisions enact separate degrees of prohibited relationships. Section 4C uses the term husband and wife. There are other provisions which deal with, which specifically used gendered terms. The general pattern of these provisions, including the specific provisions enabling or entitling women certain benefits and the effect of sections 19 to 21A, is that even if, for argument's sake, it were accepted that section 4 could be read in gender-neutral terms, the interplay of other provisions which could apply to such queer couples in such cases would lead to anomalous results, rendering the SMA unworkable.
From breaking news, detailed analysis, in-depth interviews, and explainers, follow the Times of India. Subscribe to our YouTube channel. Don't forget to like our videos and hit the bell icon to stay updated with the latest.